What types of personal injury cases does Trilby Misso handle? Unfortunately, people suffer injury and illness, and that can happen for a variety of reasons. At Trilby Misso, we have helped over 40,000 Queenslanders navigate their personal injury claim and access compensation. In most cases, Trilby Misso represent injured people in what we call a negligence claim. This is where a duty of care is breached, and as a result, you suffer injury or illness. In some serious cases, even where there is no fault on any party, there may still be an entitlement to claim compensation from your total and permanent disability or TPD insurance. The most common types of negligence claims are: car accidents are unfortunately a common occurrence, and injuries can vary from minor to catastrophic. Examples of a motor vehicle accident are two cars crashing, a car colliding with another vehicle, cyclist, pedestrian, scooter or truck, dangerous driving of one party causing an accident, forklift or tractors on a road causing an accident, stolen vehicles causing accidents and injury, and hit and run accidents. An accident does not necessarily have to happen on the road for there to be a right to make a claim for compensation. It is recommended that you seek legal advice as to the very specific circumstances of your accident so that you may fully understand your rights and obligations. Workplace accidents are commonly referred to as a work cover claim. Accidents at work can happen for a variety of reasons, such as poor or no training, faulty equipment, unsafe practices, bullying, errors and mistakes of your co-workers. It is recommended that you seek legal advice as to the very specific circumstances of your work cover accident so that you may fully understand your rights and obligations. A public liability claim can arise from a variety of circumstances. The most common claims arise from slips, trips and falls in public places as well as private residences. More unique claims can arise from an animal-related injury such as dog bites, fire, explosion, a faulty product, food handling or hygiene issues such as food poisoning, construction sites, schools, TAFEs, universities, a private home, rental property, physical or sexual assault, sports centres, play centres and playgrounds, trampoline centres, boats, jet skis and watercrafts, or go-karting or even skydiving and recreational activities. It is recommended that you seek legal advice as to the very specific circumstances of your accident so that you may fully understand your rights and obligations. You may have a TPD insurance policy. It is also possible that you have TPD cover as part of your superannuation fund. Some people do not realise that they have TPD insurance. Lawyers can help you establish if you have TPD cover and if it is possible to have more than one policy. A claim can be made on your TPD insurance when you have suffered serious injury or illness and are prevented from returning to work or returning to work in the same capacity that you once did before you were incapacitated. Each claim will depend on the terms and definitions of the specific insurance policy and the medical evidence. Proving that a party is negligent is not necessary to make a TPD claim. A common question is whether you can make a claim for negligence, like in a motor vehicle accident or a work cover claim, and also make a TPD claim. In most cases, this is possible, and there is no reason why you cannot make both types of claim. It is even possible that you have more than one TPD policy. You can claim from each fund and have multiple TPD claims for the same injury or illness. It is recommended that you seek legal advice as to the specific circumstances of your claim so that you may fully understand your rights and obligations. A professional negligence claim arises out of the negligence of someone providing a professional service. An example is a doctor or a lawyer. A doctor providing negligent services may cause that patient to suffer further injury or illness. A claim against that doctor would be considered a medical negligence claim. In terms of personal injury, a professional negligence claim may arise against your lawyer if they were to give you poor advice, miss important timeframes, or if they were to advise you to settle your claim for less than it would likely be assessed in court. This is called undersettling. It is recommended that you seek legal advice as to your specific circumstances so that you may fully understand your rights and obligations.